Phil, while I've been busy working up in New York last week or so, the of course the guidance coming out of Washington D.C. has not stopped, and I want to catch our viewers up on a couple of things. First of all, the Department of Justice issued some new DE&I guidance, and I want to chat just for a minute or two about what that might mean for businesses and contractors. On July 29, 2025, just a couple weeks ago. The Attorney General Pam Bondi issued new guidance about DE&I programs that it describes as violating federal anti-discrimination laws. I want to make it very clear that this memorandum applies not just to recipients of federal funding, but it broadly applies to any entity subject to the federal anti-discrimination laws, including public and private employers, schools, and contractors. So this guidance from the Department of Justice is more broad than just recipients of federal funding. It applies to all businesses in the country. And this guidance identifies specific DE&I practices that the Department of Justice considers unlawful or presumptively discriminatory and lays out what they call 9 best practices for compliance. So I want to make sure that, I want to make sure that employers are aware that this is out there. And basically, what it does is it declares unlawful many common DE&I practices, including race-based scholarship, hiring preferences for candidates from underrepresented groups, and training programs that rely on race or sex-based classifications. It extends potential liability to so-called proxy discrimination, where facially neutral criteria like lived experiences or geographic preferences are used to achieve outcomes without direct reference to prohibited characteristics. It targets the use of race or ethnicity to determine access to facilities or resources, including quote unquote safe spaces, race-specific lounges, or other forms of segregation based on protected characteristics. It prohibits programs or participation eligibility criteria based on protected characteristics, such as requiring applicants to identify with a specific racial or ethnic group or limiting access based on sex. Just a couple more. It requires oversight of third-party recipients, making grant recipients and prime contractors responsible for the practices of sub-awardees and their contractors. And it has a whistleblower provision. It encourages internal reporting and creates legal protection for employees who object to DE&I practices on anti-discrimination grounds. So this guidance is from the Department of Labor. The Department of Justice is pretty expansive. And again, I just like to bring up, you and I were talking pre-show, Phil. This is the Department of Justice, and when you hear DOJ, that has criminal implications. And I just want to encourage employers to be aware that this is out there.
Wow. I mean, that's huge, and I'm sure. Just looking at that when we just talk about the employment law, that's going to have to be a conversation. But I'm going back to when I practiced HR and I was working in large corporations, and we had practices. So I'm just checking some practical applications, things that I was familiar with back in the day, where we would we would show favor to minority-owned businesses, women-owned businesses, with different contracts, to try and support and promote those types of organizations. What I'm hearing here maybe is that may not be the best practice at this point.
Well, not only is it probably not the best practice at this point, for those of us who operate here in Missouri, and in particular in the city and county of St. Louis, the city of St. Louis has suspended its MBE, WBE program that it used to run. That's minority business enterprises, women-owned business enterprises, in light of this federal guidance. And so again, employers need to make sure that they are aware of this. And we've talked before about it's expensive to be the test case when the
Sure.
government wants to come after you, and whether this DE&I guidance from the Department of Justice would pass muster if they bring a claim or more seriously bring criminal proceedings against an organization. It can be expensive and with the criminal aspect, very risky for anybody who's practicing these types of programs in the workplace.